Hello, everyone. This is the Legal Side podcast of workers' compensation with Richard and Paul. Paul?
Hello, everyone. My name is Paul Taylor. I'm a licensed paralegal by the Law Society of Ontario with a specialization in workers' compensation law and human rights law. If you want to reach out to either one of us or be part of our podcast, you can contact us through the links below. This week's topic is a very interesting topic. It is the tort of insurance bad faith. In civil law, they have torts, like criminal law, you have section whatever, fraud, whatever. In civil law, in Canada and English common law, they call it torts. So there was this new tort created called the tort of insurance bad faith. And it's to deal, or it's the court's response to insurance companies acting deceptively with their clients by not paying. And our topic today is the tort of insurance bad faith in relation to the WSIB. It is an insurance to calm everybody down, workers' compensation of worker compensation. And I just want to make that very clear, the definition of the two. Insurance is something you pay and as a privilege and everything, whereas with workers' compensation under law is an exchange of rights where you lost your right to sue your employer and in return you were given a right to workers' compensation. Now, I'm not going to go down the rabbit hole of that conversation, but that's the distinction that I make legally of the two. So, in insurance bad faith, Richard, I have a legal book. I don't know if anybody can see it because of the thing there. Yeah, horrible. Sorry, my apologies. And it covers a broad topic of conduct constituting, and I'm going to put my
So what's
glasses.
the name of the book and the author?
It's called Insurance Bad Faith, third edition by Gordon Hilliker, Hilliker, and the publisher is Lexis Nexis.
Yeah, it's quite a thick book too.
Sorry?
It's quite thick.
No, actually, it's pretty, well, for
Is
me,
it
it's pretty
thin?
thin. Yeah.
Oh,
I
all right,
don't know if
all
you can
right,
see
okay.
that. Yeah. My apologies for the ghosting. So what it said basically was conduct constituting bad faith, and it goes on and it gives a list. And I'm just going to quickly read the list. And I'm sure many injured workers dealing with the WSIB and workers' compensation boards are going to go, oh my God, that's me. So, unwarranted allegations of misrepresentation or non-disclosure in policy application, and I would say that would be like claiming pre-existing conditions, failure to reasonably investigate and evaluate the claim on the part of the insurance company or the compensation board, unduly delaying the investigation, evaluation, or payment of the claim, failure to reasonably assist in claim preparation or advise of policy rights. Oh, I love this one. Bias in the selection and use of experts. We've discussed this about medical experts quite frequently. Here's my favorite one. Harassing, intimidating, intrusive, or deceptive investigative practices. Placing unwarranted conditions on payment of benefits. Unwarranted allegations of arson in cases of fire, and I'll talk about that case, or fraud in relation to loss. Unwarranted disputes in relation to the value of loss, refusal to pay undisputed portions of a claim while negotiating the disputed portion, paying less than the amount provided in the policy, and refusing to provide details for the basis of denial of the claim. So a lot of those are general conducts, and you can get into each one, and the book does. That's why there's a book. But basically, what started it all in the case of allegations of arson, if you remember, Richard, there was a famous case a few years ago, Pilot Insurance v. Witten. Witten was a woman who her house burnt down, and I believe she lost her husband and her son, and that was tragic fire. The fire department, the fire marshal, the police, all of them said no, it was an accident. The insurance adjuster, for some reason, accused her of arson. They had no basis, no evidence, no reason to. In the end, the Supreme Court determined the reason why they did was because they just didn't want to pay the claim. They were trying to save money. And this is a very common practice with some insurance companies. And in the end, the Supreme Court awarded $1 million in punitive damage over and above the actual, compensatory and everything else. And it was a landmark decision because it was the highest amount of punitive damages awarded. And from that case, this new tort developed of insurance bad faith. And what's surprising, Richard, is that one would think that, insurance companies would get the message. No. And the next case in history that I recall that comes right to mind right away is a case of AIG v. Branco. Branco was a worker, an injured worker actually. And in Canada, when you are a worker and you work outside of Canada and your employer is Canadian, they have to insure you through private insurance comparable to workers' compensation. So his employer had employed him where he worked, I think is in the Middle East somewhere, and they used AIG Insurance as the insurance company to insure him and some other insurance company while he was injured. And the issue with his claim was he went to the insurance company's doctor, their medical expert, for an assessment. He did what they asked. Their doctor didn't send the report to the insurance company. Because of that reason, they suspended his benefits, canceled his policy. In the meantime, what I didn't know, and I found out later, was he actually went to another specialist and his own doctors, and they sent reports to the insurance company. They ignored it all. In that case, he was awarded $4.5 million, part of which was also punitive damages. And that I remember reading the case, the judge had really slammed the insurance company because they said the insurance adjuster had done this before. And like, you're not getting the message, basically. And this is a common theme. What concerns me is the parallels that I'm learning about insurance, the model, is that it seems to me that the boards, the compensation boards, are doing the same thing. And somebody had said to me that David Marshall, the former president of WSIB, was an insurance man. In fact, I heard that the board of directors at the WSIB presently, there's three insurance people sitting on the board. And I found that interesting because they're not, I mean, they're sort of employers, okay, fine, but specifically picking them concerned me.
Well, take the cases that I have at the office currently. We have 6 decisions that we appealed to the tribunal where the WSIB states the worker is recovered and all the doctors state they're not. And essentially, then what happens is the worker is involved in years of appeals stating, I'm not recovered. Here's my doctors stating I'm not, and no doctors are stating I am. So if there's a case where one doctor states they are recovered and say 3 or 4 doctors state they're not, then the WSIB is obviously leaning towards not paying entitlement, but they're not acting in bad faith. They're just leaning towards a situation where they can disentitle people from benefits. Where no doctors state they're recovered, then what the WSIB is doing is saying, we're substituting our medical opinion for those of the doctors. We think you're recovered, i.e., you had a back strain, it should be better by now. I.e., you had a back strain, you've got underlying degenerative changes. We don't see how the underlying degenerative changes could be made worse by the strain, even though 3 doctors say they see how the change could be made.
Richard, that right there, when I hear the pre-existing thing, and it again, your class action that you were very successful with, and that was the issue of the board, in my opinion, wrongly using an alleged pre-existing condition. The one thing, and this we should do as another topic, is for myself personally, and I'm sure many injured workers, when you work in a heavy, dangerous, repetitive work environment, the workers will have what we call as repetitive strain injuries on their backs, their arms, everything on their body, and they're not discovered until a sudden workplace accident. And what concerns me is that the board will then label these injuries as pre-existing age-related injuries when they're not. And there was a medical report given to me by, I think it was David Newbury of IWC, a really good one. And it was published in the New Zealand Medical Journal. And it basically said somebody at the age of 20 or 30 years old having degenerated disc disease is virtually impossible as an age condition. It is work related. You have to look at their working conditions. And if you notice, Richard, when the board and their forms, the worker form, employer form, doctor form, nobody asks, what's your work environment like? What do you do? And they'll say, oh, I lift 50-pound bags of flour every day, 600 of them. Well, there's a very good chance this person has work-related injuries of repetitive strain injuries, and it's not age-related. And that's a concern. That's a topic we should do another day because I'm going to go down a rabbit hole, and I apologize.
We, when we brought our action on the non-economic loss awards, which we alleged the WSIB was illegally deducting for pre-existing conditions, when the AMA guides themselves said they should not, and so did the board's policy unless they were major or moderate conditions pre-existing. The reason was I'd sort of had enough. It's like you see somebody doing a robbery and you shout out, stop, or you dial 911 on your cell phone because you can't take it anymore. You don't want to see this theft. So that caused us to do the a lawsuit in a class action form against the board. And the legal fees were, I think we ran up about 70, $80,000 of our time because we had to go to court twice. We lost the first time, then we had to go to the Court of Appeal. We have, your paperwork is numerous. So two lawyers working on it. We ran up a huge amount of legal fees. Now I'm looking at cases where three doctors have said this worker has symptomatic degeneration from the work accident. No doctors say they don't. WSIB says we're not following them. Let me give you a case that I didn't want to do. The worker has three doctors, including a specialist physiatrist, saying the work accident disability is not resolved. And a physiotherapist said they should be all better in 6 weeks. Not that they saw them after 6 weeks, but they should be all better in 6 weeks. So the board said we're going to ignore the three doctors, which were two specialists and one GP. We're going to ignore them, and we're going to follow the predilection of the physiotherapist who said they should all be better in 6 weeks. The board, after 4 months of appeals, reversed the decision, and the client wanted to sue the board for bad faith. And my problem with the lawsuit was the board was being stupid, but were they being malicious? Because if three doctors versus one physiotherapist, get on the ball, and if you're not happy with the three doctors, don't just be beholden to the physiotherapist who's making a prediction. Go get a medical assessment yourself of what's going on. That one I think should have been acted on, but I wasn't like 100% certain. So where three doctors all say there's a problem, none say there's not. This would be the board just sort of making a mistake as opposed to bad faith. Now, the mistake they're making is purposeful. They purposely want to pay as little as possible. But it has to go beyond them wanting to pay as little as possible to them acting maliciously.
See, I would make a distinction, Richard, between the decision maker, meaning the individual doing this, who does have immunity so long as they act in good faith, and that's fine, and then the board having a covert policy, an unwritten policy to say, get all the workers back to work, we don't care. And I believe it was David Marshall who implemented that. And that's not my opinion. That was the legal opinion of Butterworth, the legal go-to book in Ontario. That would be different. And what's interesting in the law in Section 179, is that the staff have immunity, and that's why injured workers, what frustrates me is, and I understand them doing it, is if you're my case manager, I want to sue you because you wronged me. And it's completely understandable, but legally it's wrong. And this is why they're always losing. They need to list the employer, the WSIB, for the wrong actions of the staff, regardless of, in my opinion, if it's in bad faith or not, because the employer is vicariously liable for the conduct of their staff. So I think there's two things as one is conduct of staff, but you don't list the staff member as the defendant. You list them in your pleadings and say, Richard did this to me, Richard did that. But as a defendant, you just list the WSIB. And in section 179, correct me if I'm wrong, it literally doesn't give any immunity to the WSIB, where the immunity is to the staff. And I think the lawyers for the board often, in my opinion, in dealing with them, try and do like a reverse immunity from their staff to the board. And I think that's wrong. Like it's fine as a business and a government agency, your staff will make mistakes. That's fine. But somebody has to pay for those mistakes.
Well, when we did the case in the Nell and lost at the first level with the judge's decision was as long as they're acting within their jurisdiction, i.e., they're making Nell decisions, they can do whatever they want. So if they're not following some law, such as the regulation, which says you can't deduct for minor conditions, who cares? They're within they're just acting the way they want to because they're in charge.
But then I would
Obviously, the
argue,
Court of
are they?
Appeal didn't agree,
Yeah.
but uh,
But I would argue
this
in that,
judge was not an
yeah,
idiot.
no, no, I know the judge you're talking
They
about.
ruled the board can do what they want.
But I would argue that, well, to an extent, right? Because they can't, like my argument would be in the issue of return to work. The board can say it's safe for you to return to work, fine. If you follow their direction, and this is what I often say to the board case managers, if he follows your direction and he gets injured, or worse yet, killed or injures somebody else, are you liable? And of course, they'll say no. So then I say, well, why should they trust you? Where's the accountability? You know what I mean? And that's the problem with the misinterpretation, in my opinion, of that section of the law, right? Where there is an accountability. Like if a police officer in Canada, at least, does wrong, they are held accountable to an extent. Some would it's arguable, but I'm looking just at the law in general, right? Like that's the whole point of our legal system is to hold those who've done wrong accountable, right?
Well, I think what is happening is that there's no accountability for the case managers when they rule that we're following the physiotherapist and not the doctor. So after 4 months, the WSIB said, we're changing our mind because the worker was appealing it, and the next person dealing with the appeal said, that really doesn't make sense. But where was the accountability for the case manager originally? Where is the accountability to the worker who went 4 months with no job, no money?
See, in that case, I would argue it's not the accountability of the case manager. We have no control over what the employer's employees do. We do have control through the legal process of what an employer does. If they choose to hire a bad employee, if they choose not to train them, if they choose not to fire them, well, that's fine. But they're going to pay through the courts, right? And then that's when people, when they've been wrong, should be allowed to sue. In this case, the WSIB as the employer, Wisiat, or whoever, you know? And I think that's the problem with the courts is they're missing that. I get that the staff have immunity. Workers have immunity in employment law. If you walk into McDonald's, an employee does something wrong, hurts you, you don't sue the employee. Well, first of all, because they don't have any money. Secondly, because they work at McDonald's. No offense. Um, but then two is McDonald's is the one with the money, but it's McDonald's that did the training, hired them. Just you know what I mean? And that's the reason why you hold the employer accountable. Employer vicarious liability, right? And I think workers, when they're going at the board, they miss this. They take it, rightfully so, they take it personally that that case manager wronged me, but they miss that it's not the case manager's fault per se. It's the board's fault, the employer who didn't properly train that worker. We heard, remember, the president of the union for WSIB saying their training's cut way back, right? That they've been told just basically shut up and do this, follow what we tell you to. Then when things go wrong, as we've heard discreetly, the higher echelon at the WSIB are then blaming the case managers, their own staff, which in my opinion is a very bad employer. You don't blame your staff, you accept responsibility and you deal with it and then you move on, you know?
Well, I guess one of the things, if we conducted this lawsuit, would be to try and depose one of the senior people at the board as to what is the training and what are the repercussions when there's a screw up.
Like one another point to make when you're talking about physiotherapists. So if you're the case manager and I provide you 3 reports, and I often hear this term with injured workers, the board or the tribunal even will cherry pick the medical evidence. And there's 5 reports. I'm losing my thumb, sorry. And one of them, a physiotherapist report, who just says, yeah, Paul can go back to work. Doesn't provide any reason, medical, objective findings, as the board always says, or nothing. And the case manager picks that wrong report. Then they haven't followed the proper process. And there was a decision that I mentioned before, 1229/19, the Wisiat decision, at paragraph 66. It actually does an excellent job. It was a beautiful decision that listed the 10 points in weighing medical evidence, a medical report. And it talks about credentials, quality, the like a physiotherapist in this one
So
would
what was the decision number again? 1229
slash 19.
and which paragraph?
And it's at paragraph 66. For those interested, we'll post it in the show notes.
All right.
And it was an excellent decision that literally goes through and tells you how to weigh a medical report from an expert. So the decision maker, whether it's a case manager or a vice chair at the tribunal, should do this with all their medical reports. So if you look at the 5 reports and 4 of them, they passed the mustard. But then the 5th one, the physiotherapist report, they never met with the person before. That's a huge issue. They have no credentials in the area of the injury, meaning he's maybe just a physiotherapist and you need an orthopedic surgeon or whatever. Then that report shouldn't be considered as, I guess you'd say, as relevant evidence in, like in law, like in court, when relevance over, it's very prejudicial is what I would argue.
Well, to sue the board, they have to go beyond making a mistake to a systemic policy to ignore doctors. So one of the cases obviously is where a private investigator finds that the worker is driving around, and the board says if you can drive, you can work. And then 3 or 4 doctors see the worker's case of driving around and say they still can't work because just because they can drive doesn't mean they can do their job for a few hours a day. So uh,
That
in
reminds me
those
of
cases, what you have is the case manager interposing their medical view based on the driving versus the doctor's medical view based on examination, medical knowledge, and seeing the driving.
Yeah, I was gonna say that reminds me of a famous case, and I was actually at the Court of Appeal where 3 injured workers were one, the board was appealing the conviction being overturned in a lower appellate court, and 2, the injured workers were appealing. And the case was called Workplace Safety Insurance Board v. Curtis, 2018 Ontario Court of Appeal 4401 under Canley, those interested. And in that case, the Court of Appeal literally found in all 3 cases that the board had no medical evidence. And Richard, this goes without saying, it should go without saying, but seemingly it doesn't, is where it reminds me of witch hunts. If you want to learn about witch hunts and witch trials, just Google Salem witch trials. And 29 people back in the 1600s, I think it was, in Salem, Mass, were found guilty of being a witch. Two girls, 12 years old, were diagnosed by a doctor with witchery, and they were all sentenced to death. It wasn't until the governor's wife was accused of being a witch that they said, okay, enough. And that's the problem. That's why we have a legal system, and people miss that. So people can't just accuse you, Richard, you're a witch, and then you're sentenced to death. It's like, what the hell? It's to try the evidence, try the accuser. And you know what I mean? And I think when you're dealing with this whole compensation system insurance thing, it seems to be that people are in positions of authority are forming opinions, but they have no actual real evidence to prove their opinion.
Well,
And this is where things are going.
one of the things I've done last week was I sent out to about 90 representatives of injured workers a request that if you have a case where the WSIB has gone on their own medical opinion without any backup from a doctor, and you have a decision overturning that decision, please get in contact with me because I'd like to consider doing this class action, but I need multiple examples of what they're doing. And I've got two or three replies. One of them says they have the doctor's issue. The other were cases of bad faith, but not with the doctors, with other issues. So what I'm going to eventually have to do is call all 90 reps and see if I can get them to send me at least one case, because if I've got six, I assume the other reps at least have one running around. And that would be enough to show the court this is not a one of error. This is a policy, because if I'm suing them, it's not because you screwed up the life of this one client. It's because you're doing it purposely as part of an overall policy, as opposed to one example of, say, negligence by the case manager. So we'll see how that works.
And there was another decision at the WSIAT where the board had literally ignored a medical report, and it was 1193/21, where the WSIAT overturned the decision and allowed the appeal. And there was an issue of the board felt that the osteoarthritis and everything else was the reason and not the work injury, but they had no medical to support their position. The only medical confirmed the work injury, and the symptoms were the result of the work injury. And it's interesting to see that so many cases where the board is doing this, where they're finding creative ways to deny claims. I know you say, well, that isn't bad faith, but in the very definition, that actually does raise to the level of civil bad faith. Like, you know what I mean? The tort. Um, it was interesting in the book and reading it with the Canadian private insurance industry that the author of the book actually said that in the States, there's what's called as systemic bad faith. Like there's where the insurance adjusters and even the investigators or case managers will, do this insurance bad faith and the insurance companies pay, and that's fine. But then they said there was this systemic bad faith that they identified. But he actually said that it's not as a big an issue in Canada. You know what I mean? And they defined it systemic or institutional. Institutional would be the term. I think, and correct me if I'm wrong, Richard, where you identified that with the WSIB, with the NEL thing, where they had a covert policy of denying claims based on an alleged pre-existing condition, right? It wasn't a case manager, it was a system-wide policy, right? And that's where it's a bit, in my opinion, that's a bigger problem. Where it's one thing to say, yeah, the case manager or the appeals officer made a mistake. Okay, cool. But for example, the other issue that's identified is unemployability. and that was David Marshall in 2010, went to the legislature, said we're going to deal with it. And it was identified back then that he said all workers work. He didn't base it on medical with his policy. He literally said everybody's going to go back to work. That concerns me because you can't impose that system wide, right?
Well, let's leave it there, and I'll continue doing my groundwork to bring this action. So thank everyone for watching, and see you in a week or two.
Yes, thanks everyone. And if anyone has a similar case like Richard said, reach out to Richard or myself in the contact information and we'll see if we can add it to the list. Right, Richard?
Thanks. Yes.
Yeah.